I was just looking at the legislative intent. It is contrary to legislative intent to undo a valid order for protection in which the defendant was personally served with and has knowledge of simply because of unsuccessful service attempts of the petition for permanent order. Now, it's contrary to the ratification of the United States Constitution that required the signatures of those that ratified it to undo a valid order for protection, an order for protection that is invalid. The petitioner didn't petition the court because there's no signature of the petitioner. Yes. Actual notice and opportunity to be heard was not given, and it violates the Violence Against Women's Act. Right. That would make it invalid. You cannot add words to court documents. You can't put superior on there because you want to. It actually has to have the real signature of the county clerk to be valid. When you don't personally serve the respondent, the law says you have to continue the attempt of personal service until such time as the court agrees that there's a possibility of a court-ordered certified mail if I had an address. Yes. Or you can put it in publication after attempting service, real attempts of service. Now, I've always had the same email address. I've been in Clallam County for the most part of the last 4 years. In fact, the sheriff's department called me and served me, and I was more than happy to receive. I never tried to avoid any personal service or any court hearings. Now, if the protection order had been valid, if you had given me personal service or had put it in publication for the required number of days, and I had chose not to respond, that's what you would consider a valid protection order. The petitioner would have signed it. Yes. The protected person would have signed it. Yes. It wouldn't have been served in a public library. Right. It wouldn't have any forgeries on it. That's right. There would not be any scribbles. You would have filled out the address and telephone number of where the court is. Yes. There wouldn't be any forgeries. It would be the actual signature of Heidi Lee Budnek, the signature that's on the marriage certificate, on the Social Security card, and on her driver's license. Yes. You would have done everything according to the required legislated laws of the state of Washington. The federal laws that it must conform to. And it would have been 100% valid. Then, if I had been in that city and I had attempted to violate it, I would have been able, you would have had to prove that I was there, that there was an actual probable cause arrest. You would have had to prove that I had the intent of contacting Ms. Budnek, violating the protection order, whereas obstructing 50 to 100,000 emails and having the King County Administrator decide that I wasn't going to be able to legally use my lawful use of my email addresses and the internet. As I read this here, the legislative intent is to issue valid orders for protection where the defendant was personally served with and had knowledge of before there was a court hearing, and because of the unsuccessful service attempts of the petition for permanent order. Now, I don't know where the process servers are of every attempt at personal service of all the temporary protection orders, but I'm thinking that Clallam County really did not attempt personal service. I'm almost 99% sure that this court document, without the petitioner's signature, without the respondent being served before it was issued, without the respondent having the right to due process, violates all 10 amendments of the Bill of Rights, the 11th, the 12th, the 14th. Article number 2, Article number 3, Article number 4, Article number 7, and it is obstructing my right to sue for impeachment every Supreme Court justice in every state of the United States, and all of those in the United States Supreme Court.